Misrepresentations of a product. Hey, we've heard about that. Well, let's take a look at a real case, Now, this hadn't happened some time ago, but I think it demonstrates several things. There was a case that was brought in the Eastern District Court of California, that's a federal district court in the Eastern District of California, by a plaintiff on behalf of herself and others who contended that the Captain Crunch cereal that indicated they had crunch berries really did not have crunch berries. That is correct. She contended that she and others thought that possibly the country was filled with crunch berry bushes and that the cereal should have had crunch berries in it. And she brought claims saying that she was deceived by the advertising that indicated that the cereal contained crunch berries. Now, she made this allegation even though the box said that it contained sweetened cereal, oats and flour, and that it was flavored, but it never mentioned any actual berries. Notwithstanding this, she brought the claim contending that the allegation that it contained crunch berries was deceiving to anybody who purchased the product. She did admit in her moving papers that she understood there were no berries in the cereal. So the court took a look at this, heard arguments on behalf of this plaintiff who was concerned that there were no crunch berries in the Captain Crunch cereal, and heard the arguments on behalf of the manufacturer that said, with all due deference, a reasonable consumer could have figured this out and would have realized that this was not a representation of actual crunch berries because crunch berries do not exist. Well, the court looked at this and it gave it some consideration and it said, you are right. You are right, manufacturer of the cereal, because in fact there is no allegation that in fact the world does have crunch berries, and the disclosure on the box indicates that it is basically a cereal with high fructose syrup and sugar, and therefore there's no representation that there are actually crunch berries within the crunch berry cereal. In view of that, the court said, I find that it is not reasonable for a consumer to make the allegation that they were deceived because they were deceived supposedly over the existence of something that never existed and that they reasonably knew never existed. Okay, bring you this case, as you bring cases every week, so you understand basically how the law moves forward. And what do we learn from this one? What we learn from this is something, one, very important, and that is we hear lots of news about, well, shall we say, frivolous lawsuits. Here's an example of someone who would say a frivolous lawsuit. But did this case go forward? No. On the very first motion that was brought, a motion to dismiss the case, the motion was granted and the case came to an end. Second thing we learn is that with regard to consumer misunderstanding, with regard to deceitful representations to consumers, false representations to consumers, the consumer is a reasonable person, and most statutes are written in that manner, that a reasonable consumer would be misled. Here, we found, for all intents and purposes, that we were dealing with an unreasonable consumer because she never believed that there were crunch berries, and therefore she was contending that the cereal manufacturer was arguing that the cereal lacked something that she knew never existed. She was unreasonable. Okay, so we understand how the law works. We understand frivolous lawsuits are turned out very quickly from the court, and additionally we find that when a case is brought for misrepresentation to a consumer, the standard is reasonable consumer. If the consumer isn't reasonable, well, the claim can't be brought. All right, bringing this case and bringing cases every week, I'm David Allen.